state of Florida in this honorable court.
There you go. All right.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have one case on the docket today. That case is East Coast Waffles, doing business as Waffle House and Brentwood Management Services versus Jonathan Hazelden. Counsel, if you're ready, you may proceed.
Good morning, Chief Judge, judges, and may it please the court. My name is Ryan Davis, and I represent the appellants, East Coast Waffles, doing business as Waffle House and Brentwood Management Services. With regard to this appeal, at this time, I'd like to reserve 3 minutes for rebuttal.
So noted. And counsel, if you'll speak up a little bit more loudly, it's a little difficult
course.
to hear. Okay.
So today, the appellants are here to request this court take one of two actions. The first is to either remand this case back to the judge of compensation claims for a proper analysis of the major contributing cause of the claimant's condition and with regard to compensability of the claim. And the second would be for a complete reversal of the award of compensability based on the lack of competent substantial evidence contained within the record. The facts of this claim are very straightforward. Mr. Hazelden worked a double shift, approximately 17 hours, at which time, throughout the shift, he developed excruciating back pain. At the next shift, at approximately 7 a.m., a new manager came on duty, and Mr. Hazelden had talked to the manager. The two men decided that they would try to manipulate Mr. Hazelden's back in order to alleviate his pain. So Mr. Hazelden stood against a wall, his fingers interlocked behind his head, and then the manager pressed down on Mr. Hazelden's elbows. Mr. Hazelden stated that he had no feeling, he felt nothing from this motion. He had no pops, no additional pain, nothing. However, throughout the day, Mr. Hazelden's pain continued to progress, even to the point where he stated that he had neurological symptoms on the left side throughout his leg and was unable to move his leg. That led to Mr. Hazelden requesting workers' compensation benefits. They were denied at inception, and the two parties each retained an IME physician. With regard to the request for remand, Silverberg v. Palm Beach County School Board is very informative and provides guidance with regard to the major contributing cause analysis. On page 10 of the final compensation...
Counsel,
yes.
do you accept the fact that Mr. Hazelden had a herniated disc and some other, certain conditions of his back? There are certain problems with his back as reflected in the medical documentation, right?
Yes, Your Honor. The MRI, the diagnostics revealed herniated discs
Right.
and degenerative conditions, correct.
Right. And, it wasn't perfect testimony, but there was some reference by Dr. Modestin that that was caused by at the time, something happened at work at the end of work, and that was caused by what was going on at work, either the popping of the back or the pain he was suffering after standing for 18 hours. Why is that not enough of a evidentiary connection?
Well, yes, Mr. Hazelden did have findings of a disc herniation. However, the claimant pled the back popping incident as the mechanism of injury. And because he developed pain prior to the back popping incident, the back popping incident would be a separate cause. Now, Dr. Modestin stated that the back popping incident could have caused the herniated disc. However, as we found in Tico Energy v. Williams, a chronic degenerative condition such as the findings in the claimant's lumbar MRI and diagnostics is enough to trigger a major contributing cause analysis. So while there's no dispute that the objective findings were there, there's not necessarily a single cause to be considered, but multiple causes to be considered, which would trigger the major contributing cause analysis.
Well, couldn't it be, what is it easily divided up that way, though? So if he's standing for 18 hours and then the manager comes in at the end of the shift, and he tells him, hey, my back's hurting, and the manager proceeds to pop his back. Are those two incidents or just one at the end of the day?
And I believe it is very difficult to discern in this case because the two separate incidents in the appellant's position are so closely related in time. However, the first incident in developing back pain over a 17-hour shift, there would be no definable accident. There would be no definable moment in which the accident occurred, I should say. Therefore,
So, yeah, and I mean, since you bring that up, let's go to that for a second. So if, in order for someone to have compensable back pain at work, it has to be like that? It can't be something that develops over the course of 18 hours?
No, it definitely can develop over the course of 18 hours, generally either seen in a repetitive trauma injury or in an internal failure, an idiopathic condition that manifests itself at the time of the idiosyncratic pain. So because Mr. Hazelden did suffer that pain, it's the the appellant's position that if Mr. Hazelden wished to proceed with a workers' compensation claim, he should have identified what was caused by the 17-hour shift instead of trying to isolate a specific incident in the back popping, because there are two separate mechanisms of injury here. And with regard to the shift, even the claimant, Mr. Hazelden's own independent medical examiner, said that the 17-hour shift did not cause his condition.
By itself, I'm assuming that there's a little possibility that just standing for 17 hours is going to herniate your disc. Is that your position?
Yes, that was the position of each of the two
Right.
independent medical examiners. And because in and of itself, being that there would be at least one other mechanism or one other contributing factor, that's why the appellants believe that the major contributing cause analysis must be performed, along with the other the findings, such as the claimant's degenerative condition, the osteoarthritis, such as his pre-existing left knee condition, in which he had not only a ligament graft but also a nerve graft, and because he complained of the neurological radicular symptoms throughout his left leg and was told that he would have to have a subsequent hip replacement, they are causally connected to his symptoms and complaints of pain with regard to.
How does any of that have to do with a herniated disc?
Well, it's the position of the claimant and appellee that the herniated disc is causing stenosis on the spine, which is then causing the neurological symptoms down the claimant's left leg, when in realistic terms, the claimant had a prior neurological condition throughout his left leg, and it is indicative of additional degenerative changes throughout his left leg, left hip. And
Right, but it
leading
didn't
to the
stop
spine.
working until after this incident.
Excuse me?
He didn't stop working. He was apparently working with all that other stuff before this incident. So there was something that happened on a particular day where that's the sort of the dividing point or the point of demarcation on the timeline. I mean, all this other stuff, he may have had it, but he clearly was working with it. But something happened on that particular day, the working 18 hours followed by having his back popped by his supervisor, that then resulted in him not being able to work any longer.
Yes, Your Honor, and that's
So I
why
don't understand the emphasis on, aside from, I'm not sure you fully understand Silverberg, I don't walk me through why that is relevant. So if we have to back up, so if we have an individual who's been working, he has certain conditions, as it turns out, but he was managing to work there. But then something happens on that day. He's standing for 18 hours for a shift, and then at the end of it, he suffers back pain, and then his supervisor tries to fix it by popping his back. And after that, the pain just gets worse, and he tries to work for a couple more hours after that on another shift, and he still can't, and he can't do it. What's the relevance of all those other conditions to this particular instance?
Well,
Other than, I mean, it seems that on these facts, the work had certainly had something to do with what he's suffering now.
Yes, Your Honor, and the appellants aren't challenging that there is no causal connection whatsoever. The appellants are challenging that the major contributing cause of the claimant's condition is not the back popping incident as pled by the claimant.
Well, let's take a step back. We've talked a lot about cause, and the back popping being the cause of the need for treatment and the cause of the injury. Is it the occupational cause? Was the back popping part of the work that the claimant performed for Waffle House?
No, and actually the position later for reversal, but we can obviously discuss now, is that the back popping did not arise out of the claimant's employment. It's referenced within SOIA that obviously when an employee is leaving work, that is incident to their employment. They must leave, they must get there, he was on the premises. However, what differentiates this case from SOIA is the fact that Mr. Hazelden deviated from leaving to seek back popping or manipulation, some kind of pain relief from from the manager that was on
Well, I think
duty.
there's some facts in dispute about whether he was or wasn't on the clock, so let's just leave that to the side. Let's assume he was on the clock and he was on premises. Did this injury occur, did it arise out of the work that he performed for Waffle House?
The appellant's position is no, it did not. There was nothing with regard to the back popping, seeking of these, the manipulation that arose out of his employment. Now, from a very tenuous standpoint, if after working the 17 hours he developed this pain, he was going to seek some sort of relief in order to further the claimant's, the employer's interest, then yes, we could have an argument, a very tenuous, strained argument, that the need for the back popping arose from the employment, such as him seeking the back popping then arose from the employment. However, that is a very long, drawn-out causal connection.
Well, let's take a hypothetical. Let's assume that, on the job an employee starts developing a similar type of injury and really has a maybe more complicated kind of medical procedure. And I'm trying to think of that, what would do that? Someone, let's say an employee chips his tooth on a piece of equipment that he's operating, and then another employee says, well, let me extract that for you. Under what facts would help us kind of put that into the arising out of bucket versus not that bucket?
Well, I guess it would depend on if the claimant was seeking compensability of, let's say, something that happened from the infection following the extraction, or just the compensability of the tooth breaking itself. And in this situation, the tooth breaking would obviously be arising out of his employment. He was performing duties there. If he then, for some reason, sought someone else to extract the tooth, whether it was offered, whether it was requested, seeking those sorts of benefits from someone not licensed, not a medical provider, it has nothing to do with their employment. It does not further the interest whatsoever. The claimant would have no position as to get better from an extraction when all he was suffering from was a broken tooth. He could have easily left and gone to seek medical treatment.
Counsel, just a quick follow-up question. To what extent does it matter that this was his supervisor or this was kind of employer-condoned back manipulation? And so, I recall a decision, it's the electric sock decision. I don't know if you're familiar with that. It was cited in Silberberg where the claimant was burned as a result of wearing electric socks, certainly something that he brought into the working environment, but the employer knew about that. And this court decided that that constituted an injury arising out of employment. So I guess my follow-up question is, does it matter that here we had kind of the employer's blessing or involvement in the manipulation?
I would say to an extent. However, in those situations, I would say that the employer's condoning the wearing of the electric socks was in furtherance of the employer's position. It was an employer in furtherance of the claimant's comfort in that situation. And here, there is nothing with regard to the claimant's seeking of that benefit that would have been of any aid to the employer, especially given that Mr. Haslam stated that the manager showed up at 6:40 for a shift that was to begin at 7 o'clock. So Mr. Haslam could have had no more than 20 more minutes on the clock. How would seeking something from that manager been in furtherance of the employer's interest when Mr. Hazelden was to leave work at that point? It wasn't something that was continuously allowing Mr. Hazelden to continue his duties. If it would have been further, maybe at the beginning of a shift, I could see a more stronger argument made there. And also, to address the point made with regard to the 17-hour shift, I believe there's a similar case cited in Silverberg in which an individual suffered an internal failure in their neck after looking up at a computer screen for an extended period of time. However, you have to actually examine whether that particular situation caused the herniation and the claimant's current condition, and a major contributing cause analysis had to be considered there. So with regard to that, I would like to reserve the remaining time for rebuttal.
Certainly, thank you.
Thank you.
I will add 2 minutes to your time for rebuttal, and I will similarly add 2 minutes for the appellee's time.
Thank you, Your Honors. Ken Schwartz on behalf of Mr. Haselden and Bradley Sopotnik as his trial attorney. First, let me apologize in advance. I'm freezing cold, and I tend to talk very quickly when that happens, so please feel free to interrupt and ask me to slow down if needed. On behalf of the appellant, Mr. Haselden, we feel that this is actually a fairly simple matter insofar as most of the arguments that were raised by the appellants at this point are related to issues that should have been resolved at the trial level. The idea that there is some pre-existing condition was rejected by the JCC. The information that opposing counsel has been bringing up today as constituting the pre-existing condition was considered by the two IME physicians and was considered by the JCC and was not found to be a relevant finding. To the extent that if it ever had any relevance, the employer carrier's burden at the trial level would have been for them to find some admissible medical expert testimony to say that this was related. There is none in the record. There's nothing to say that anything that was referred to in the reply brief, I believe they made reference to a lumbar finding on an MRI report from a radiologist on page 107 of the record, and that they give significance to saying, well, there you go, there's your pre-existing condition. Well, respectfully, there's nothing in the record below that says that that was a pre-existing condition, especially where that MRI report was from 2021, and the date of accident was 2019. So even to the extent that that report says that there were degenerative findings, well, there's no medical testimony to say what the period of degeneration was, what triggered it in the first place. Was this simply age-appropriate degeneration? Was this degeneration that existed in some form in his body or some condition that existed in the claimant's body that was then accelerated by his work? We don't know. The record doesn't include that. And to the extent that the JCC didn't accept the employer carrier's argument below, then all we're doing now is looking to see whether the record contains competent, substantial evidence to support what the JCC actually did find.
Well, what is the evidentiary link between what your client is suffering now in terms of what's debilitating and either the back popping or the standing for 17 hours before that?
So,
Other than a doctor just kind of guessing, like more like a logical analysis, well, he wasn't suffering the pain before the incident and then he was suffering it afterwards, so ergo it must be the major contributing cause.
well,
Is there anything else?
I believe your phrasing on direct to Mr. Davis was that it wasn't perfect testimony from Dr. Mondest and the claimant's IME. I agree. It wasn't crystal clear. It wasn't the model of clarity. But he nonetheless did say that the major contributing cause of the need for care was the work. And at the time he was being asked, in the first instance, he was being asked whether that was because of the back popping incident or the effort to pop Mr. Haselden's back. And we do have no clear testimony that a pop happened. That's acknowledged. But he was then asked again for clarification. I think the word was calculus. Would the calculus of treatment have changed if you were saying that the back popping was the cause instead of something else? And he said, no, it would be the exact same thing. So and then he proceeded to list all the various things that he would feel would be appropriate medical care as a result of the claimant having had this at least 17-hour shift that caused him to be standing over the grill doing the work in the course and scope of his employment, and that resulted in back pain.
No, that resulted in back pain, but what is the link between that and the herniated disc and the like?
So you're asking, is there a
The
specific
actual physical symptoms, because pain, obviously pain by itself is not going to be compensable, but you're going to need some sort of bodily injury or some physiological evidence to corroborate that. And I'm assuming it's the herniated disc. Am I missing something?
I don't think you're missing anything, Judge.
Okay.
But there's objective medical findings,
Right.
and there is a link made by a doctor whose testimony is admissible that the need for care is a result of the objective medical findings, and he's saying that the causation was the work accident. The major contributing cause was that. And yes, it was largely because, he arrived at that conclusion largely because there was no pain or pre-existing conditions. The claimant presented for work had that difficult shift, and he had the back popping incident, and then he had pain and problems after that. So he did the best he could with the information available, and again, not the model of clarity, but he did testify the major contributing cause of the need for care was the work accident and was based on objective medical
And
findings.
just for clarification, what is the work accident that you're referring to here?
Well, as the JCC put it, there's one of two that could, actually strike that. There are two possible accidents, and in either case, the outcome doesn't change on appeal. So frankly, I don't know that it makes a difference that we need to, at this point, pin down one and say it has to be this, it has to be that, because.
But in the PFB, the only reference really is to the back popping incident. There's not this, long 17-hour shift and trauma, and I don't see that in the trial memorandum or any other place. So where am I missing that becoming the alleged cause of the injury?
Well, I don't know whether there's, let me actually focus the question on what was pled, because that seems to be what you're asking. Where in the PFB does it say that this particular thing happened as opposed to that?
Well,
But the
because it's
claim-
clear it's disjointed, right? We agree that the JCC is identifying two potential accidents. And if you go to page 11 of his order, right, it's an injury either as a result of the 17-hour shift or the back cracking or back popping.
Yes, but at this point in the litigation, I don't know that it's necessary for us to have to identify one, because the petition itself is to put the employer carrier on notice that a claim for benefits is being brought by an injured worker arising out of an accident that happened in the course and scope of employment. That's the allegation. And in the face of the petition, it asks a series of questions, address, phone number, a whole bunch of different things, and of course a description of the accident. Those are there to put the employer carrier on notice of what the source of the need for benefits to be provided is.
Correct.
But if you look
So
at-
if this were a repetitive trauma injury, right, there's a different kind of notice and response. Would you agree with that?
I would agree that the notice would be important, but what I was leading up to, Judge, I'm sorry to cut you off of any further question, but the pleading itself asks for specific claims for benefits, and that's medical care for his back injuries. It doesn't specifically say in the claim for benefits, either in the petition for benefits or the pretrial stipulation or the JCC's opinion, that this is all tied to anything in specific, that the need for care is only related to the one thing you identified in the face of the petition. It is a claim for medical benefits, period. The question then becomes, well, why does he need that? And that is where the petition for benefits is requesting that the employee put the carrier on notice of what happened. It's to put them on notice so that they can then raise the appropriate defenses. They have 14 days to say either thumbs up, we accept it as compensable, thumbs down, we deny it, or we don't have enough information, we're going to invoke the pay and investigate provision and have 120 days to sort this out. Moreover, they have the ability to claim under 44192 that that the petition itself lacked sufficient information. It wasn't sufficiently specific. There is a definition of specificity in Chapter 440, and there's a mechanism in place where if you don't feel you've been given adequate notice of what it is, you bring that to the JCC's attention and say to them, Judge, I don't think that we know whether we're supposed to be looking at this from a repetitive trauma angle or from an acute incident angle.
But couldn't they fairly assume from the PFB that it was actually specific? That, I mean, it specifies the back popping as an incident. That's a specific moment. Why would they ask for clarification if it's already specific? It's then they go to the hearing and then find out later, oh, this, the repetitive trauma might, or the standing for 18 hours beforehand is part of the claim as well. So I don't understand how that helps you.
Well, the claimant's testimony at deposition was clear as to what he felt was going on. He said at the end of it, towards the end of his shift, approximately 6:40 a.m., as Mr. Davis indicated, he was nearing the end of what he described as about an 18-hour shift when Malik, his general manager, supervisor, showed up. And the first thing that they discussed was his excruciating back pain from work that day. So from the claimant's deposition forward, they had to understand that there was back pain already present before this back popping incident arose, because the back popping incident arose out of the claimant's allegation of back pain.
Right, but the pain itself can't be the injury here.
The pain itself can't be the injury.
And we don't know what otherwise was causing the pain All we know is that after he sees a doctor later, that he has a herniated disc and some other trouble with his back that the MRI and other exams show. And there's no indication that anything but the popping of the back itself, if you want to call it that, whatever, we're just talking about popping because that's what you pleaded.
Whatever Malik did.
Originally, sure. The evidence points to that was the moment that caused it and nothing else.
Well, that's what the claimant alleged from the beginning because he wasn't sure what exactly the mechanism was. He's no doctor, no more than
But
I am.
isn't that what Dr. Modestins testified to, that it was that back popping incident that was the mechanism of the injury?
The first time he was asked about major contributing cause, the way the question was phrased, it did ask about that, but then again, there was a circling back after, I think it was cross-examined, I don't remember if it was Mr. Pope who did it or the claimant's attorney, but the follow-up to that was, well, I guess it was the claimant's attorney, Mr. Spotnik, asked him, well, would your recommendations for this care change in any way if it was only him having worked that significant period of time and not having gone through this back-popping effort by his supervisor? And he said, no, it would be the same. So the connection is already made that the major contributing cause in the doctor's mind of the need for care must have been the work performed as the grill operator, the long standing and bending, et cetera, and he wasn't testifying that the back-popping incident, however you want to call it, created anything additional.
And I understand that. I understand that, but by the time you filed your pretrial memorandum, you would have known that, right, to adjust. And as I read it here again, it centers around the back popping incident, discussion of course and scope and horseplay, and there's not discussion of repetitive trauma or the long standing or the 17 hours. And so, if your suggestion is that as the evidence developed that became a theory, where is that, and where is the employer carrier on notice that they are to defend against that at the final hearing?
I don't think there's any specific moment where the claimant said, well, this is only the long shift or the back popping, but we're alleging both, one and the alternative to the other. There is no clear notice of that happening. I agree with you on that. But at no point did the claimant say that the back popping was the only reason that he had any issues going on. He always knew that he had a difficult time with the shift and came in, Malik, the supervisor, came in before the end of his shift while he was still on the clock, and he knew he was going to have to be coming back to work soon because of the split shift that he had only a few hours later. He mentioned to his supervisor that this was going on. The supervisor either brought it up himself or the claimant asked him to do it, but nonetheless, this happened while he was in the course and scope. And from then, it was, I guess you could say, a merger of the two, if you will. I know that opposing counsel is trying to paint this as we have the work, I guess the repetitive trauma of work, and therefore you have to have a separate legal analysis of the medical the burden of proof changes, is what he's saying. And then you want to separate out the other one because it's more acute, and that's just a different level of proof. But I don't think that that's necessarily the analysis, because even though there was no specific notice to the carrier, hey, we are alleging an alternative theory, at no point did the carrier present any evidence of any pre-existing condition. They never said that there was anything else that the judge eventually relied on to say that I accept that the claimant's work was the only cause of.
Okay. Well, let's assume we agree with your merger, theory on the causation. Explain to me under Silverberg how either of these accidents and the injuries were caused by the work that Mr. Hazelden performed for Waffle House.
Is that a pre-existing condition question or an arising out of question?
It's an arising out of it. See, the claimant's initial burden. Did the claimant meet his burden to show that his injuries arose out of the work he performed for Waffle House?
Well, I would say under Soya, which was released a week after Silverberg, that yes, absolutely. Because although he was working at the Waffle House and he was a grill cook, he wasn't making waffles at that specific moment, but he was working in furtherance of the employer's interest as a restaurant that happens to serve waffles amongst other things. So he was doing his grill cook work It was before the end of his shift that his supervisor showed up, and he complained immediately of excruciating pain from his work as a grill cook. So I think that's unquestioned. He was in the course and scope, and it was arising out of.
Yeah, but you don't get to the any exertion. This is not an any exertion case. This is an internal, I mean, he's suffering an internal problem, which under Silverberg gets you outside the any exertion question. Now it's a question of were there factors or risks or exertions of the work that exacerbated or caused his idiopathic or idiosyncratic reaction. So, I mean, it's not just a question whether he was doing anything for work in this case.
Well, Mr. Silverberg's situation was that he was essentially getting up out of his chair while in the course and scope of teaching, right? And the medical testimony at the time was from a neurologist, I believe, who said that Mr. Silverberg had some sort of pre-existing predisposition to having, I guess it was orthostatic
Well, he had some vascular, something idiosyncratic to his vasculature, which everyone has their own vasculature.
Sure.
They're all going to react differently, and Mr. Silverberg's problem is that he reacted in a way different from others to the same kind of exercise.
And the medical testimony in that case connected those two dots.
Right.
The difference here is that we don't have those two dots connected in any way. What we have is a lot of argument from the appellants, from the employer carrier, that there's some relevance to what happened to the claimant's knees years before, more than a decade before. They're saying, oh, well, he had some accident with his knee, and therefore that's automatically a pre-existing condition, put in quotes. But,
yeah, but put all that aside. I mean, you got to get to a point evidentially. I mean, you're the claimant, so you have to have some evidence that links. So if it's what caused the herniation of his disc or something like that, and it would be highly unusual for someone to have a herniated disc just from standing. I mean, I'm not doubting the pain that he was suffering, but that could be a variety of things. But what you have in terms of the medical evidence is that he was that he had a herniated disc and some other things that certainly would explain his inability to work subsequent to that. But you don't have the link. Well, what was it about the work that he was doing that caused that herniation? Unless you're not relying on just the herniated disc and you're relying on some other amorphous condition that I'm not aware of.
Well, again, getting back to the limited testimony that we do have and the lack of perfection in it.
And answer this too. So as you're talking about the testimony, this is depositions only, and I know this is a thing that the work comp bar does all the time, is they refuse to actually call live witnesses in front of the JCC. If you know that you have a weak deposition, why not call the IME to testify in front of the JCC? And then the JCC can ask questions if he's unclear, and then you all can do follow-up at the hearing and have a clearer record.
Well, as the appellate attorney and not the trial attorney, I can't speak to this case and why anything was or wasn't done. But all I can tell you is that we did have Dr. Mondestin's testimony, and we did have him do the best he could with the circumstances of being an out-of-state physician, not all that familiar with workers' comp and the terms of art that we are required to use. He did make sufficient link for the JCC to find that the major contributing cause of the work accident the need for care was the work accident, largely relying on the subjective complaints of the plaintiff, of the claimant, and the fact that there was no pre-existing condition that made that was not relevant to Dr. Mondestin. And I know I'm showing I'm over the time, but
You can conclude, yeah.
the significance, excuse me, the significance of Dr. Mondestin's testimony is that he didn't make any link between whatever he saw in the medical records or the claimant's presentation to connect whatever conditions could be considered pre-existing and related to this back injury. He didn't make any connections between the two. So as far as the back injury was concerned, there's nothing in the record that says that there was anything like what Mr. Silverberg had. There's no neurologist testimony that there was some predisposition to having something. There was no orthopedic surgeon or neurological surgeon saying that whatever Mr. Hasselden had as a result of his injuries when he was younger, his nerve pain in his lower leg, regardless of which side it was on, regardless of which knee was operated on, there's nothing to suggest that any of that had anything to do of any kind with any back pain or problems, herniation or otherwise. So when he came to work on the date of the accident, he was essentially, for present purposes, a clean slate. So he then leaves at the end of the day with two things having happened to him. He had an extremely long shift, almost 18 hours of bending over the grill, which Dr. Mondestin himself said, when I do 8 hours of surgery, I come out with back pain, and I don't think I have any pre-existing problems. So we have that. Then we have the supervisor coming in and doing something to manipulate him because of that back pain, and then he leaves, and overnight he develops even more pain than he had on the job, which he described as excruciating. So although
Counsel, I'm going to give you about 20 seconds to wrap up
Can
on this.
I add a follow-up? to that?
Well, then I'm going to concede to my counsel, my
Whatever I
colleague
am,
here,
yeah.
whatever today, to ask another question.
And this will be the last one. The reason I asked about the deposition transcripts versus testimony, this could have, your position would have, would be more compelling if the JCC did any credibility findings whatsoever. But he didn't, because he's got the same records that we have, that we're looking at. I mean, I can look at, pages 80 through 82 of the record in Mondestin's testimony, where he says it could cause this condition, and with the clumsy questioning about 51% causation, and it's vague in that answer. Can't I read the same transcript and say, yeah, that just doesn't make the connection, regardless of what the JCC made the determination about? Since he's not doing any weighing, he's just looking at the same records that I'm looking at.
I would say that your suggestion on how to handle the evidence is probably the best one, but unfortunately that ship has sailed for us, and really all we have is a limited record, and we have the JCC actually making a credibility assessment in accepting the opinions of Dr. Mondestin over those of Dr. Key, the employer carrier's IME, and whether or not you can, sitting in your role as an appellate court, look at those same documents and make a similar assessment. Yes, I think you're probably very capable of doing that, but the fact is this is now in front of a court of errors, and the question becomes, what does the Court of Appeals do? Is there sufficient evidence in the record to say that the judge of compensation claims made the right decision? And I would respectfully suggest that there is CSC to support support the JCC's decisions on what credibility assessments he did make, and that there is sufficient objective medical findings in the record and testimony from the claimant that makes it clear that he did have a work-related accident, whether you want to call it one or two or a combination. Nonetheless, it happened, and as a result, he was awarded benefits, and we believe that the record supports an affirmance of that on appeal.
Counsel, thank you.
Thank you.
We will extend the appellant's time by 4 minutes.
Thank you, Your Honors. With regard to the major contributing cause, the employer carrier's IME physician, Dr. Kelly, did identify other causes for the analysis to be right. Now, he did not identify another single major contributing cause, and that was only because he stated that within a reasonable degree of medical certainty, he couldn't identify a major contributing cause.
How can you be medically certain of your inability to make a call?
Simply for the fact that there are so many competing causes, or the competing causes are so close that he could not state within a reasonable degree of medical certainty that one of those potential causes
Was his standing for 18 hours a contributing cause?
Yes.
It was a contributing cause?
Yes.
Okay. And the back popping, for lack of a better term. We haven't come up with a better one, obviously. So we'll call it back popping for now. The back popping was a contributing cause,
A
yes?
potential contributing cause, yes, Your Honor.
Potentially.
We have no idea exactly what, we know the objective finding was the disc herniation. We apparently have the claimant's IME stating that the herniation is causing the back pain and the radicular symptoms. However, we have no evidence stating that any of the work actually caused the disc
I'm just talking about the
herniation.
back popping. I'm not talking about a legal determination. I'm just talking practically speaking, looking at this record. Was the back popping a contributing cause?
To the disc herniation, Your Honor?
Yeah.
I say, based on the testimony of Dr. Mondestin, yes.
Okay. So we have the standing that could be a contributing cause, or is a contributing cause, and we have the disc popping as a contributing cause. How do we, as a court, make an assessment of what's major in this instance?
Well, respectfully, I believe that's a finding that the JCC has to make based on medical testimony.
Why can't I make that finding? Because, again, neither side chose to call any live witnesses except for the claimant. So we're stuck with deposition transcripts, and not great depositions at that. Why can't we make the same assessment and determine what's major and what's not?
Well, Your Honor, I believe you can find that, well, to answer your question pointedly, this is a finding of fact, and this is something that the JCC is tasked with determining. Now,
Based on a record review, which both sides chose to do, which the work comp bar does all the time, is just dump a bunch of records and deposition transcripts on a JCC and expect the JCC to make heads or tails of all this.
yes, Your Honor, and respectfully, as counsel pointed out, is not the best situation, especially with regard to the specific case. However, it is the claimant's burden of proof to prove that the whatever workplace accident is alleged is the major contributing cause of the claimant's condition within 50 or
Sure.
at least 51%.
Well,
So-
but at 51%, so on that, so that definition has nothing to do with this case, because that's on 44009, and that has to do with resulting injuries, not the actual injury. So MCC is in the definition of arising out of in 44002 instead. So it's not a question of whether it's 51%, it's just a question of whether the work was the major contributing cause of the injury, whatever that means. And so my question goes back to, how do we assess whether, so the standing, or whether it's one event, starting with the standing and ending with the back popping?
Well, respectfully, I believe that is why this case needs to be remanded for the judge of compensation claims, because
To do what?
to perform that major contributing cause analysis.
I mean, the same thing that we could do. I mean, how is the JCC in a better position to make that assessment than me?
Given the current facts, I don't believe necessarily the judge of compensation claims would be in a better position because of the way in which the evidence was presented. However, it's still a finding of fact that must be found by the judge of compensation claims.
By doing the same record review that, again, the same that I asked your opposing counsel, it's the same record review that we would be doing.
Right.
I mean, how is the JCC in a better position? Usually their standards of review reflect the competency of the respective tribunal. I mean, obviously, we're not great at making credibility determinations, nor could we, because we don't see the witnesses present in court. But we are quite capable of reading records. We do it every day.
Yes, Your Honor. And so I think the way in which to resolve the conflict that you're bringing up is to determine whether there is competent substantial evidence to support the award by the JCC. In this case, as you pointed out, Dr. Mondestin regularly said this could have caused the claimant's condition. Now, the city of Titusville v. Taylor, we found out that could have caused is not within a reasonable degree of medical certainty necessary to award benefits.
Based on the way this case was tried, was the JCC entitled to consider the 17-hour standing as a potential cause of the accident?
I believe he could consider it as a potential cause of the claimant's condition, which would have had to have been pled as a separate and distinct accident because of the separate and distinct burden of proof necessary, and the fact that the claimant never chose to seek that as an accident and has no medical evidence in support of that as an accident leading to the claimant's condition. It should have been considered under Newark v. Webster Training Center, which if an accident happens at work and is not deemed compensable, then it is still proper for a major contributing cause analysis. But to go on, Gallagher-Bassett v. Mathis provided, there was a situation in which a medical professional stated that they couldn't determine what was pre-existing and what condition happened as a result of an accident without medical records or diagnostics to interview. It's this exact same situation here. Mr. Hazelden developed back pain prior to the back popping. The back popping is the alleged accident. Now, obviously, this is very close in time. However, there are no records to support this, and because Dr. Mondestin relied on the fact that he would need to review those records, or the pushing on the claimant's elbows could have caused the herniation, there's no competent substantial evidence to support the JCC's award of compensability.
Okay, thank you, counsel. Thank you both. This court is adjourned.
All rise.